nation's capital, the American Enterprise Institute for Public Policy Research presents Public Policy Forums, a series of programs featuring the nation's top authorities presenting their differing views on the vital issues which confront us. Today's topic: whom do judges represent?
In our 200-year history, the judiciary has been accepted as the guardian of the Constitution against the emotional and political storms which sweep through a people and a nation seeking solutions to ever-changing social tensions and a complex of problems in a continually expanding and demanding society. Judges, it was conceived, would ideally be appointed on the basis of demonstrated professional capability, personal and professional integrity, and proved judicial temperament, the merit principle. In practice, over our 200 years, of course, other factors, political affiliation, religion, race, ethnic background, geography, and personal friendships have played a role, but always it was supposed as handmaidens to the merit principle. In the past few years, however, two events have changed the focus on judicial appointments to move other issues to major importance with merit. First, in the echo of taking his oath of office, President Carter issued an executive order establishing the U.S. Circuit Judge Nominating Commission to make recommendations based on merit for all future judgeship nominations at the level of the U.S. Circuit Court of Appeals. The commission panels, 13 in number, were to be composed of lawyers and non-lawyers and required the inclusion of both men and women as well as members of minority groups. At the same time, President Carter urged all home state senators, traditionally masters of federal district court appointments, to establish selective commissions of their own and to follow the same guidelines and standards as the Circuit Judge Nominating Commission. At the end of 1978, President Carter said, "If I didn't have to get Senate confirmation of appointees, I could tell you flatly that 12% of all my judicial appointments would be black, 3% Spanish-speaking, and 40% would be women, and so forth, roughly the percentage of each group in the total population. This, the affirmative action principle." This new policy of emphasizing race, sex, and ethnic origin, as well as merit, came with the second important event, the passage of the Federal Omnibus Judge Act of 1978. It established 152 new judgeships, which, with even larger numbers of vacancies created by retirement, resignation, and death, gave President Carter well over 300 appointments before his term ended. Nearly 1/3 of his nominees were female, black, or Hispanic. Thus, the issue of whom the judges represent came to public policy debate on whether professional qualification was being diluted in an era of participatory democracy by political considerations, more properly the province of the executive and legislative branches of government. To guide us through this examination of the judiciary's place in the system, we have a highly expert panel. To my far right, Dr. Sheldon Goldman, professor of political science at the University of Massachusetts at Amherst. To my immediate right, the Honorable Griffin, former U.S. Judge in the Fifth Circuit and Attorney General of the United States in the Carter administration. To my immediate left, Senator Orrin Hatch of Utah, Chairman of the Senate Judiciary Subcommittee on the Constitution, Chairman of the Labor and Human Resources Committees. To my far left, Dr. Walter Berns, resident scholar of the American Enterprise Institute. And before coming to AEI, he was professor of political science at the University of Toronto. And now to begin, gentlemen, I would pose the same question to each of you in turn. To put it mildly, the Founding Fathers were imprecise on this issue. In establishing the three equal branches of government, the executive, legislative, and judicial, to act as a check and balance to one another, did the Founding Fathers consider the judiciary should be representative in the same sense as the executive and legislative branches? If not, how would the judiciary be different? Senator Hatch, will you start?
Well, there's very little record in the early history of our country of the Founding Fathers actually attempting to do anything along those lines. As a matter of fact, there's, if anything, an indication that they did not want to. And I think what they wanted to do is have this, since both the Congress and the presidency were representative bodies, the administration representative, the Congress representative, I think they wanted literally to have the court to become a body that would rise above particular political implications. I remember when Attorney General Griffin, my good friend here, testified, he said that Mr. Carter was prepared to appoint to the federal bench a black, Hispanic, or woman lawyer who was found to be less qualified than a white male, so long as the appointee was found qualified, which indicates that the Carter administration was willing to, as long as they found a minimum standard of qualification, choose anybody else they wanted to, but preferably blacks, Hispanics, or women.
All right. Mr. Bell.
Well, the founding fathers, I do not believe, had in mind that the federal judges would represent anyone. It was part of the justice system, and one of the main purposes for having an organized form of government is to have justice. To the extent that there's any representation that's based on the caseload, you get the number of judges that you need to handle cases. The Carter premise was to make the federal judiciary more representative of the American people, women, blacks, Hispanics, other ethnic groups. But there's no sense in developed to be a political system in the sense that judges represent anyone. They serve the American people, but they do not represent anyone in a political sense.
Dr. Berns?
Well, Mr. Daly, you said the Founding Fathers were imprecise on this question. In a way, I suppose you could say that. On the other hand, the question never arose as to whether the judges should be representative in the way we're talking about it today. When they established representative institutions, as Senator Hatch has mentioned, they established the constituencies and the electoral methods by which these people would be chosen. When they came to establish the judiciary, it never occurred to them that the judges would be representative in this sense at all. To use the term in this context, one would have to say, well, when the federal judges have a constitutional case before them, they represent the people who wrote the Constitution in a sense, or they represent the American people. They represent us in our constituting capacity, but they do not represent us in any political sense, and that, of course, is why they are not elected.
Dr. Goldman.
I would agree that judges certainly were not thought of as being representative in the sense that the executive branch or Congress is representative. Indeed, that was the reason for lifetime tenure on the federal bench, in order to have an independent judiciary free from the winds of whatever political currents may sweep through Congress. Yet also, I think the Founding Fathers, many of whom were in the first Congress and who enacted the Judiciary Act of 1789, did have some sense of representation in that judgeships and indeed even the Supreme Court were geographically based. Each Supreme Court justice was assigned to ride the circuit and to act as a circuit judge. Now, it's true in part that was for convenience, to be sure, but also I think there was a sense that while we were a United States, there were differences within the country. And of course, also I think it's fair to say that the Founding Fathers had thought of the Constitution as a living document. And indeed, as we have seen over the years, there has been representation in the sense not only of geography, but in terms of party affiliation, and to some extent in terms of ideology or policy orientation on the bench. And above all, I think we have to keep in mind that judges represent basically themselves. They represent their attitudes, the values that they've acquired over a lifetime, their judicial philosophy that they have evolved. And it is in this sense, the psychological and behavioral reality of the art, really, not the science, the art of judging, that I think underscores our central concern and I think justifies the actions of the Carter administration. And I know we'll be getting into this in greater detail.
All right, Senator Hatch, you've noted that, quote, there are no clear, commonly accepted standards by which judicial nominations are weighed, end quote. What standards for weighing nominations would you urge on your fellow senators, and is there some way we can build these standards into the selection process?
Well, I would personally want to find the most well-qualified individuals we could. President Carter said that he wanted a merit system of selection of judges, but it became anything other than that, in my opinion. I think the major legacy that the Carter administration has left to the country is his judicial selection of about 300 judges. And I might add that many of them are of the judicial activist mode. We had one judge, a nominee, who, in front of our committee, who, when asked if you had to choose between what the law is and your own conscience, what would you choose? He said, my conscience every time. Well, you know, I think we've got to get beyond that. I think lower court judges ought to believe in the principle of stare decisis, and they ought to abide by the principles as set down by the Supreme Court. I think that the Supreme Court itself should move away from judicial activism and live within the Constitution and the laws themselves. I'll give you a couple of other illustrations. One nominee in response to one of these questions indicated that, well, a large number of nominees indicated that they would be judicial activists on the bench. They wouldn't be limited by the law. They were going to do whatever they felt was right. I think that's the wrong way to choose judges. So I think we've got to look at their background. We've got to look at their educational standards, their degree of acceptance in the field of law. We have, I think, independent rating systems there that can help, the rating systems of the Bar Association, and I believe their attitudes towards upholding the Constitution and enforcing the laws as they exist.
If I may interject.
Yes, Dr. Berns.
To begin with a point that Senator Hatch made, he referred to Mr. Carter's statement about appointing judges on the basis of merit. It turned out that 97.8% of the judges he appointed were affiliated with the Democratic Party, a higher percentage of partisanship in appointment than any other president in the last 100 years, with the sole exception of another Democratic president named Woodrow Wilson. That I offer as an aside. A serious question of Mr. Goldman and Judge Bell. You have both publicly stated your support of affirmative action in appointment of judges. Is that for the benefit of those who will be appointed to the bench, or is that because you think the law will be improved by a federal bench that is representative of the population of the country?
You directing that at me?
Mm-hmm.
Both of you, I think.
You both have a shot at it. We're free and open.
Well, Senator Hatch said two things I want to answer. Now you've said two things, so I've got to answer four things. It'd be probably better if we could go one at a time. But I'll start off by going with the last thing you said, affirmative action. Affirmative action was designed solely to cause the American people to have more confidence in the federal courts as an institution. If we have women lawyers, and we didn't have many women lawyers until 1960, thereabouts. We had very few black lawyers until recent years, very few Hispanic lawyers. And it seemed to me, and seemed to President Carter, that it was a good thing for the system of justice to have some of these groups represented on the federal court. But that was a Carter affirmative action plan. I did say once, and I'm glad to repeat it, that if we had 5 qualified people, one was a woman, one was a black, one was a Hispanic, and we needed someone in that particular court to make that court more representative, we would pick the black or the woman or the Hispanic, but they would first have to be qualified. And we used commissions, and we always would have a qualified list. I never appointed but one, never nominated, recommended to the president, but one person who was found unqualified by the American Bar Association.
No, but General Bell, you have to admit that President Carter seemed much more pleased with the number of women, Hispanics, and blacks that he placed on the bench rather than the qualifications of them. And I think, in all honesty, the majority of the the women, blacks, and Hispanics who were recommended were among the highest qualified they could find within those categories. But he seemed more interested in the numbers than in the actual merit selection process, and I think you'd have to admit that.
But he was, he pledged this, you know. Oftentimes, presidents, even the president we have now, pledges things that the American people might be glad if he'd go back on. And I've never figured out how a president knows just what it is he ought to do, except to say he's going to carry out all of his pledges. President Carter pledged this. He's very proud of it, of what he was able to do. You're right about that. The statement somebody read here about he said he'd want 40% women was something that was, I thought was pure rhetoric. There are very few women lawyers in the country. You might appoint, you're limited by the number of people who are lawyers, not who are in the population. So the 40% figure was certainly off, as well as 11% of the blacks. I think he did appoint 7 or 8% blacks and 10 or 11% women. Now, the next thing you said about the Carter administration, Professor Berns, was that President Carter appointed more Democrats than any president since Woodrow Wilson. Well, I just checked the figures this morning to see how many Republicans President Nixon appointed, President Ford appointed, how many Democrats President Johnson appointed. That's as far as it went back. And how many Democrats President Carter appointed. And they all were 90% or more in their own party. So don't pick out just one.
No, Mr. Ford was 81-point-something%. I'm using Henry Abraham's figures
here. The second
here.
thing I'd like for you to do while you're here at the American Enterprise Institute is find out how you can identify someone as a Republican or a Democrat when they are independents. You just can't say today that a person is a Democrat or a Republican always. The third thing I'd like to mention is reply to is activist. If I were a member of the United States Senate and someone told me they would not testify, they would not follow the decisions of the Supreme Court, I would deem that to be an anarchist, that we cannot have a system of law unless you follow the court above you. Above you. If you're not willing to do that, then you ought not to be a judge, and the senator ought to vote against a confirmation. And that's why we have this check in the Constitution that the Senate has to advise and consent.
Well,
and I would not vote for anyone who said they would not follow the Supreme Court.
Senator Hatch?
You go to the Wall Street Journal, they talked about the nominating commissions throughout the country. And they said the nominating commissions set up by President Carter routinely inquired into judicial applicants' views on such issues as abortion, whether they were for or against it. If they were against abortion, they were automatically shut out in some ways. Whether they were for the Equal Rights Amendment, you know, whether that, you know, and shut some of them out on that basis. And I know in our circuit, a number of the most highly qualified men ever put up for a judgeship were just knocked out because they disbelieved in abortion and didn't quite agree with the Equal Rights Amendment. And of course, then school busing came up. And they would ask questions like this, and of course, you know, I don't see how we can have a decent judiciary if we have 45% of the judges now appointed by President Carter, almost every one of which of whom lists himself as a judicial activist, and not one of whom listed himself or herself as a conservative. In other words, all of them were moderate to liberal.
In terms of this activism restraint model that you have in mind, I think that's a phony issue. Our courts have always been activists. John Marshall was the greatest activist Supreme Court justice we ever had.
Well, I guess it depends what you mean by activism.
All through our history. In fact, I have a quote here that Justice Douglas was quoting Chief Justice Hughes, who had indicated to Justice Douglas once Justice Douglas came on the bench. He said, "Justice Douglas, you must remember one thing. At the constitutional level where we work, 90% of any decision is emotional. The rational part of us supplies the reasons for supporting our predilections."
Well, but even
this is Chief Justice Hughes.
But even Justice Marshall, even Justice Hughes, and maybe even Justice Douglas would have been offended with the courts running our schools, our mental institutions, and all kinds of other societal institutions that were never contemplated to be run by the courts, which we have being done today by judicial activists who are making their own laws, many times in total disregard of what the Congress has said. And a perfect illustration is the Civil Rights Act of 1964 as amended. It says we should have no discrimination based on race, sex, national origin, etc., religion. Look what the Supreme Court itself has done with that. with the utilization of affirmative action programs, which are, in essence, government-mandated discrimination based on race or sex only, and frankly causing disruptions all over America in favor of the, quote, preferred, unquote, classes. Tell me where in the Constitution we have preferred classes.
Well, Congress and the executive branch, of course, have played a very important role in affirmative action. It was Congress who enacted the minority business and the MBE provision of the Public Works program. It was Department of then Health, Education, and Welfare that came out with its guidelines.
And it was the court in Fullilove that said that those minority set-asides were right, even though the Civil Rights Act says we should have a
that's the only.
Here was a court deferring to Congress, to the wisdom of Congress.
You can give of that. Here we are talking about the activism or non-activism of the judiciary, and I wonder whether that isn't that subject isn't necessarily connected to the subject we're supposed to be discussing, namely the question of whether the judiciary should be representative, and if so, of whom. Are the two of necessity connected? Is it so that Senator Hatch and I, who are on one side of this issue, tend to take the view against, that the judiciary ought not to be activist in this sense, and that you two gentlemen who take the other view on representation tend to support an activist judiciary? Is that so?
No, absolutely not. I think it's almost scurrilous to call me an activist.
I agree. Judge Bell was always
I was a judge 14 and a half years. I've been in over 1,000 opinions.
Well,
and,
you couldn't help.
I've been in more school cases than any judge in the United States.
And you couldn't help what the president did to you.
I was not an activist at the same time I was carrying out what the Supreme Court said the law was. That was my duty to carry it out. Now, Senator Hatch said something about these questions that these commissions were asking about abortion and other social issues of the day. In the early days of the commission, some of that happened. I appointed all of the chairpersons of the commissions, except one, 12 out of 13. I summoned all of those people to Washington and told them that I did not want to hear any more of any questions by members of commissions directed to these social issues. Questions that the Senate itself would never ask a candidate on a confirmation hearing. That had to stop, and I expected them to rule any member of a commission out of order who did that, and to give me the name so that we could replace them. And to the best of my knowledge, after the first few months, that stopped. Let me make one other point. What happens is, if you really have an activist judge, the public gets the idea that all judges are activists. And you might not have but 1 out of 10, but that makes a big difference in what the public is thinking. They say, oh, the courts are running the country now. And this is not a good thing. That's the reason I was taking offense at being called an activist. I think it...
I didn't call you that, Judge. I asked whether that was so.
Well, I thought you did, but at any rate, you ought not to have people running the country who have not been elected on our form of government.
And
that's what you have to be very careful about.
We have a bunch of judges running the country who haven't been elected, substituting their own judicial activism in many ways. And look, the fact is that...
what you have to have in mind, though, is the judges carry out the law. They are the executors of the law. And the law is made by the Congress and, of course, by the Executive Department, their participation in it, but mainly by the Congress. And to the extent that judges do what the law says they should do, they cannot be called activists. Now, if they go out and make up some law, then they are.
Yes.
Yeah. And sometimes they have to...
It's not a real issue.
Yeah.
It's not a real issue. It's
it's
the matter of
discretion. Representation.
It's a matter of discretion which is built into the system.
Yeah.
And you can't escape it. And your so-called activists don't have to be liberal. They can be conservative. The point is you're exercising discretion.
I would be just as much against a conservative activist who was going outside the framework of the law and outside of the principle of stare decisis as I would a liberal. The fact
there are
is,
precedents and precedents.
well, let me give you a perspective of a member of the Judiciary Committee who sat in on almost all of these nominations. And I have to admit, my personal impression was that the judgeship nominations, there were some great ones, there were some who were well qualified, but there were a lot of them who were mediocre, in my opinion, for these lifetime appointments on the bench. And frankly, I just felt like when we go to lifetime appointments, where these people are the closest thing to godhood on the face of the earth, we ought to get the very best we can, and we ought to do everything we can to find the very best women, blacks, Hispanics, and other minorities as well. but we ought to choose the best. And they ought to be people who at least believe in the principle of stare decisis and abiding by what the superior courts say.
We have a vast civilian audience. Would you, because you've used stare decisis many times, define it for the
well, basically it means abiding by the precedents of the Supreme Court or the higher courts, whichever the case may be. In the district court level, abiding by the precedents set by the circuit and Supreme Courts. In the circuit, Federal Circuit Court level, abiding by the precedents set by the Supreme Court itself. And we find an awful lot of lack of abiding by the precedents today in our country.
But I think
what we're happening, excuse me.
Oh, sorry.
Oh, I was just going to say that we're talking about representation. I used to worry about who should be put on the court out of the ones that the commissioners would produce. And you have to have people of good character,
yes,
ability, but above all, a federal judge, as Tocqueville once said, has to be a man of great wisdom. That's what we need in our country. And when Congress passes laws, sometimes they leave these gaps to be filled. Cardozo called it the interstices of the law. And that's where a judge comes in with his discretion. He's filling these interstices. So the thing that I was finally driven to was, how would this person handle power? That is the question. And that is really the most important thing you ask yourself when you're making a judicial appointment. And while I was president, that would be the one thing I'd always insist on. Predict how this person can handle power. If they can handle power well, they'll be wise people, and we'll have a good country. We'll have a good judiciary. But that's what it really gets down to. And in that sense, you really are representing the American people.
Yes.
Dr. Goldman.
Absolutely. I agree wholeheartedly with Judge Bell. Our judges are not legal slot machines. They never were, never will be. Judges are not fungible. Judges are policy-making public officials because that is the nature of the institution. And just to call it activism, I don't think means anything.
Well, I think you're misconstruing what we're saying. We're not talking about judges not being innovative, not being creative, not being intelligent, not utilizing all of those qualities. What we're talking about are judges who are legislating from the bench and imposing their own ideological mores and folkways upon everybody else. And throughout this process of about 300, I think a little over 300 judges, or right on the money, there were a large number of them who, though nice people, who, though qualified attorneys, and who mostly were qualified, who gave a lot of indication that their philosophy was going to be continually brought out from the bench regardless of what the law was.
Dr. Goldman?
Yes. I think it's very important not to exaggerate about judges running the country. I think when we go below the surface of these charges, we see that what is involved is a finding of a constitutional violation, that a school board has discriminated. That school board has been found to have practiced in its policies racial discrimination, and therefore where there's a wrong, there must be a remedy. And when you have some of these massive busing plans, if you go below the surface, you see it's because of long-standing, deep-seated racism and problems of violation of the Constitution. Indeed, these judges, I think, are upholding the law, the finest traditions.
You've just said, however, in defense of activism, that you
I'm saying there's no such thing.
Yeah,
really.
well, yeah, and you
saying.
indicated that the judge has a range of discretion that is almost unlimited. Now you're
I wouldn't say that.
No.
I would not say
Well,
that.
now you're telling us
that
you're talking about the necessity to adhere to the constitutional rules. Again, however, we are off on this activism business, and I asked the question, Judge Bell, I didn't say you were an activist. I pointed out that there seemed to be a suggestion here, the way we've been discussing this issue, that those of us who think the judiciary is not a representative institution tend to be opposed to judicial activism, as we're in the opposite for you gentlemen. Let me restate the question that Judge Bell answered, but you never had an opportunity, Mr. Goldman. And that was, are you for affirmative action in the appointment of judges for the sake of those who will be appointed or for the sake of the law that is to emerge?
For the sake of the country, for the sake of the judiciary, for the sake of the law, and I think as a moral good in and of itself. And let me expand on that.
And everything.
Let me expand on that. I think that if our law is to have legitimacy among every segment of our population, there must be the feeling that no segment of our population is excluded from the law.
That's Judge Bell's point, and I think it's a point well taken.
Right. So in that respect, I agree absolutely with Judge Bell. It's good and right for the country. It's good for the judiciary, too. Do you know, I just read the other day a survey that was done of state trial judges, men and women trial judges, by a very fine political scientist, Professor Beverly Cook at the University of Wisconsin at Milwaukee. This study was conducted in 1978, and she found among the male judges some very disturbing vestiges of sexism, sexual stereotypes that these judges have. I think it's healthy for the judiciary to be sexually integrated, racially integrated. I think that kind of interchange, particularly at the appellate level, is very helpful for the kinds of problems, particularly in racial and sexual discrimination, that are coming before our courts all the time.
The present judiciary is misinterpreting the Constitution on these gender points, or misinterpreting a federal statute?
No, I'm not saying that you have to be black to understand the problems of black Americans, although I'm sure it helps. But what I am saying is that black appointees, women appointees, whether they're politically liberal or conservative, can bring to the bench a very special sensitivity to these kinds of issues. And I'm not just, you know, taking this out of thin air. We've had some very recent examples in the press that have been reported in the press. For example, a Carter appointee, District Judge DeAnder in McAllen, Texas, released tapes, videotapes at the police department that showed shocking brutality at Hispanic Americans. Judge DeAnder is the second Hispanic American to serve on the bench
but Professor
in Texas.
Goldman, nobody is differing with your point that it would be good to have women, blacks, Hispanics, and other minority people on the bench. That isn't the point. And the reason that judicial activism is important here is, frankly, as part of its seemingly relentless effort to place minorities on the bench. The Carter administration many times did waive traditional requirements regarding minimal professional experience, minimal professional ability. A large number of individuals were appointed in their mid-30s or even some in their low 30s, and I supported one woman who was very young and had very limited experience in law because I felt like there weren't enough women. And I think Griffin Bell and I chatted about that, and that she should have that opportunity even though she didn't have a 10-year experience or better in the practice of law. But it looked to us as people who had to get this influx of this tremendous influx of judges, that the appointment process was subjugated to creating a good record in the record books, rather than appointing these lifetime appointments, appointing to these lifetime appointments people who would really elevate the bench, do precisely what you're talking about, be able to make wise and judicious decisions, and in the end uplift and create a judiciary that everybody in this country regards with respect and admiration. Now, I suspect we're going to have all kinds of problems in the future because of some of these appointments.
I don't think so. I've been studying judicial appointments over the last 19 years. And I can tell you on the basis of my own research that the Carter appointees as a whole differ, except in matters of race and sex and ethnic origin, differ very little, very, very little from the appointees of previous presidents.
All right. Mr. Bell.
The day I left, or the day before, I made a speech to the employees of the Justice Department in which I said I thought the goal had been achieved. We had made the federal courts more representative, and that we could now go back to what I call the strict merit system. Now, there is such a thing as strict merit system, but we've rarely seen it in the history of the Republic. That is, you take the very best person you can find. When the Republicans are in, the strict merit system means you take the best Republican you can find. When the Democrats are in, you take the best Democrats you can find. So you thereby eliminate half the people. And that's for both parties. As we get more and more independence, we'll get away from that, I guess. But At any rate, what I said that day, I believed it. I believe it now that we had achieved the goal. But in a few days thereafter, after I had returned to the Sojourns of Atlanta, what I had said was repudiated, and we went on to some other system. I don't know what it was.
Well, I think it should be noted for the record here that the repudiation came from your successor in office as Attorney General.
And not from the President's administration.
And
Benjamin Civiletti, yes.
Appointee of President Carter's.
Yeah.
We have another issue. I would like to read from the Washington Post very briefly, an editorial on selecting federal judges. And the thrust of it is that President Reagan has abolished the nominating commissions established by President Carter. That is wrong because the President and the administration had better figure out what they want quickly, or they'll discover they have surrendered an important presidential power the previous administration fought hard to win. And we've been discussing great moral questions here. Does this practical issue come into this picture, and is much of the concern that there should be wrested from the Senate the great historic and traditional powers to control judicial appointments?
Well, it is a practical consideration. Senator Kennedy, when he became chairman of the Judiciary Committee, made it clear that he would not abide by the right of a senator to stop a judicial appointment and would go on from there unless there were overriding considerations. Now, I have mixed emotions about that myself, and of course one of the arguments was the merit selection approach would work better than senators picking the judges. I think you could have a very strong debate on that issue today, whether senators do a better job because they know they've got to live with them the rest of their lives politically and they don't want to make mistakes, or whether merit selection commissions do better jobs. And I think you'd find gross bad examples in both cases and some very good examples in both cases.
I think what we saw with these merit selection commissions is that the membership of those commissions you had affirmative action. You had, and not simply tokenism, but you had, I think on the whole, something like 35% of the commissioners were women, and a similar proportion of blacks or other ethnic minorities. And what these commissions did was to expand the pool of available candidates. And ironically, you know, we often hear attacks on the selection process as being so partisan. Ironically, this was the way out of partisanship. 80% of the women that President Carter appointed were not party activists.
But I think it should,
and this is unprecedented.
It should be pointed out, however, that not all states or all senators abided by that. I believe in the Judicial Merit Selection Commission approach, and we used it in Utah, and like I say, we even brought the congressman in to participate in that process, and we think it worked well there. There are some other illustrations where it didn't. There was at least one Democratic senator who said, he was the only Democratic senator in the state, he said, I am the Judicial Merit Selection Commission, and I'm going to select who they are, and he did. And he selected quite a number of them to fulfill positions.
I had one senator tell me that if we insisted that he have a commission, he'd put his wife and 3 children on it, and that would be the commission.
My remarks were...
Was he a Republican or a Democrat?
I think he was a Democrat.
I knew he was.
I think we've opened this issue as broadly as it can be opened. The record probably should note that President Reagan, in his campaigning, made it very clear he would like to see a woman on the Supreme Court, and Senator Warner, who inherited the imbroglio in Virginia after he took over in that state, has made it very clear and has taken affirmative steps to seek out members of minority groups and women.
Mr. Moderator, if I could say one short thing, I believe it would wrap this up. And that is that there will always be a place for some effort to keep the federal courts representative of our population. We do not want to have quotas. That is a problem, and the American people continue to be confused by the difference between fairness, trying to make our institutions representative, and a strict quota system, which we cannot get.
I think
it's not only the American people who tend to get confused about that difference. Members of this panel tend to get confused about that difference too, Judge Bell. I among them.
Yeah,
and when the president says, I will appoint X% this, Y% that, and Z% that, I call that a quota.
Who was it? Who was the Attorney General who said, watch what we do and not what we say. That's
Well,
John Mitchell.
Yes, well,
Well, you better not say that about President Carter.
on this particular
Watch what
point.
he did, not what he said.
Well, you just got through saying,
Well, we
Judge
watched
Bell,
what
at
he
a
did.
certain point you thought we had gone far enough,
Well, I think-
rather than move on to the quota.
Right.
You did this in your commencement address to the Justice Department, and within 10 days, was it, your successor, Attorney General Civiletti, repudiated your point, which shows, I think, once you start this business, it's exceedingly difficult to stop it.
Well, but I don't think he did that much after I left. I think he only handled 50 or 60 judgeships, and I don't think
Just a minor number.
I don't think they reached any quota system.
All right, gentlemen, may I suggest it's time for the question and answer session? All right, may I have the first question, please? Yes, sir.
I am Professor G.C. Onyeledo from Nigeria. I'm attached to the National Institute for Policy and Strategic Studies in Nigeria. And my question is directed to Judge Bell. He did make the statement to the fact that when an activist is one who tries to pronounce what is not directly stipulated in the law. In other words, if a judge is trying to pronounce what is written in the law, now he is not an activist, but when he tries to make law, he becomes an activist. So I want to know whether you regard this as an illegal procedure where a judge tries to do something which is not stipulated in the law, or you just accept it as normal since you are operating within the common law system.
Judge Bell?
Activism would be difficult to define, and it would be the clearest definition I could give you is what Justice Potter Stewart said about obscenity. He said he couldn't define it, but he knew it when he saw it. I know activism when I see it, and the way I would define it is that if there's an unanswered question in the law, and as a judge you're called on to provide an answer, you do it with the least exercise of power possible. You have to exercise your power in that event, in those circumstances. If you go to the maximum use of your power, you probably would end up being a one-person Congress. And the American people would not like that. They would call that activism. Somewhere near the bottom of the power base is where you ought to end up. If you're a judge who respects power, then you would not be an activist. That's the best definition I can give you. But you cannot fail to act. You must act because your duty requires you to act. You've taken an oath, which inherently means that you must do your duty. And then the question comes, how do you do your duty? And that comes to, how do you exercise power?
All right, next question, please. Yes, sir.
My name is Michael Malbin. I'm at American Enterprise Institute. Mr. Bell spoke of affirmative action for the courts as being important because it helps restore or build up public confidence in the courts, and Mr. Goldman spoke about the importance of bringing to the courts a special sensitivity to certain issues. We normally speak of the courts as having two different kinds of jobs, discovering facts and stating law. And I suspect that there's unanimity on the panel on that in the part of the court's job that has to do with the discovery of facts, that the public confidence is helped by having people of different sorts of characteristics on the bench. The question is, does affirmative action help the courts when the court's job is to state the law? And if so, how?
I don't know how affirmative action would help that. I think affirmative action, to me, if we want to call what the Carter administration did affirmative action, we've got to have a, in the time we live in, everything has to have a name, so we'll call it that. The only thing I know that was designed to do was to cause the American people to have more confidence in their court system. And that meant the country was, at least perceived by President Carter as being, and I think he was right, badly fragmented by the time he came into office. We had been through the Civil Rights Revolution of the 60s, we'd been through the Vietnam War, we'd been through Watergate, and everyone in the country seemed to be stirred up. Not only stirred up, but stirred up with each other. And it was a time to pull the country back together. Today is quite different from 4 years ago. We are waking out of all of those things pretty well, I think. I think it speaks well for our country. that we've come as far as we have. But I don't think affirmative action would help. I don't think you can divide law and fact. I think you just, always law and fact are tied together when you're in the decisional process.
Anybody else like to talk about Senator Hatch?
I reject the notion or the idea that only black congressmen can truly represent black communities, or that only black judges can be sensitive to the needs of black people. You know, I don't think judges are supposed to represent communities. I don't think they're supposed to represent any particular group in our society. I don't think that Mormon judges are going to represent Mormons in the community or should be there representing Mormons in the community. They ought to represent the people as a whole. And I think, frankly, a potential enormous transformation is occurring in the form of the idea that the court ought to be representative, or that any court ought to be representative. And I think this idea results, of course, from the activist conception of jurisprudence that judges are to involve themselves in setting good social policies as well as daily interpreting the law. Now, my attitude about that is, given this activist view of jurisprudence, maybe if setting good social policies is one of the goals, then maybe activist judges are good. But I don't think that is the goal, and I reject that notion.
Anybody else want to, Dr. Berns?
I'd like to add a point to this. I don't want to beat a dead horse or a horse that's retired to pasture in plains. But again, I have to quote that statement because there's one part of it we've never commented on. I think it deserves comment. This is Mr. Carter, December 7th, 1978. If I didn't have to get Senate confirmation of appointees, I could tell you flatly that 12% of all my judicial appointments would be black, 3% would be Spanish-speaking, and 40% would be women, and so forth. What intrigues me is that, and so forth. What do you suppose he had in mind, Judge Bell, for that and so forth?
I haven't got the foggiest notion. I'm not being a mind reader. But
well,
I'd like to quote back to you what I said about John Mitchell. Watch what we do and not what we say.
And you appointed women, blacks, and Hispanics.
We did.
That, of course, does raise...
we did not appoint 40% women.
Yeah, no, of course not. But that does raise a question because, and again, once one starts down this affirmative action road, why is it that one selects these particular people, not every one of whom belongs to a minority, women, for example?
Oh, well, we appointed the Chinese, Orientals, we appointed Indians. And if you want to just go down the list, but you know, it was a representative idea, a representation idea. It wasn't any quota.
Dr. Goldman, you want to talk to?
Well, I just wanted to get back to the question from the floor, and I think that the essential point to keep in mind is we're dealing with the credibility of our institutions to all the various groupings within our society, and particularly those groupings that have been discriminated against, for which there's no question, and I don't think there's any disagreement on this panel, that not only in society at large, but within the legal profession, that there has been historic discrimination against women, against blacks, against Hispanic Americans. This is well known, this is well documented. Today, there are approximately 60,000 women lawyers. There are about 550 women judges, most of whom are on the state benches. There are many very well-qualified women, Republican women, conservative women, non-activists, even though I don't believe activism is a real thing. And I would hope that President Reagan will be appointing these women. He certainly had recognized during the campaign that there was an imbalance. That was his word at his news conference in Los Angeles on October 14th of 1980, that there was an imbalance on the judiciary.
I don't think anybody differs with that.
Right. So I think that it's important to have a selection process that is going to expand the net, to bring in not only what would normally occur, those who've been politically active, those who've been the campaign managers for senators and the like, but also those who have not been politically active, to get good people, to bring them onto the bench, and to have, in this limited sense, a representative judiciary.
One other thing that should be brought up. One other thing that we ought to bring up here today, and that is one of the greatest minds. Now, I differ ideologically with him, but one of the greatest minds, legal minds in this country, was barred from taking a federal judicial appointment because of his age, Archibald Cox. I thought that was a horrendously bad determination by this so-called wonderful egalitarian approach to what we would call gumming up the courts.
That violated the ABA standards, you know.
Well,
they would have rated him unqualified
so
because
what?
of age.
The ABA, we violated their standards all the time. We don't consider them the only source of wisdom in this country, although they should be listened to. And neither did General Bell, to his credit.
No, but on that particular one you're talking about, I was.
You were with us.
I made the decision. No, not
you
to
made
bar
the
him. Yes.
You made the. I thought you were with us.
No, we had a number of people who were being held in the wings by various senators.
Yeah.
I have this old-fashioned view that you ought to wait at least 10 years for if you're going to be appointed to the court.
I see.
And we had people in the early 70s. I didn't think I'd been a judge. I knew how hard it was that they could go up into the 80s. So you had to draw the line somewhere, and it was unfortunate we had to draw it on Senator Kennedy, but it was his man.
Well, it was as good as anybody.
All right. I think we ought to get some more questions. Next question, please.
My name is Bruce Fine. I'm from the Department of Justice. From the outset in 1789, I think it's been recognized by presidents, legislatures, and lawyers that the act of judging is really at heart a political act, and that the ideological complexion of the federal judiciary will affect considerably important public policy issues, and that's acknowledged with the Midnight Judges Act, in which John Adams appointed 17 Federalists because he thought Federalists could best protect Federalist interests. Recently, under the stewardship of Earl Warren, it was thought that activism was being exercised in furtherance of liberal interests. But there seems to be an acceptance that no matter what one tries to do to make the judicial decision-making process transcend political interest, it simply will not be done. Isn't it important that in acknowledging this power in the judiciary, that indeed those exercising the appointing power do seek to make it representative of the otherwise representative institutions that are not really exercising their rightful legislative powers today by drafting such vague and inexplicit language?
Senator, would you like to start with that? I thought so. Thank you very much.
He made a very good speech, plus the question is a very difficult question. I think that the Congress has had sloppy legislative draftsmanship for many years now. We have allowed the courts a wide open berth to interpret what our statutes are. And frankly, I think the Congress is much to blame for some of the problems that we have today with the judiciary. On the other hand, I still don't see why the judiciary has to have a tendency towards problem solving rather than grievance resolution. A tendency to employ the plaintiff as a vehicle for imposition of far-reaching orders applying to classes of individuals. A tendency to impose, it seems to me, broad affirmative action obligations upon society. A tendency towards the loosening of jurisdictional requisites so that they can expand the right and grant more standing and ripeness in particular suits, and of course a tendency to impose the judicial branch upon other institutions in the manner of an administrator with continuing oversight responsibilities. Now, it seems to me that's what our courts have been doing. That's what I define, at least in part, as judicial activism, and I think the last 4 years have accentuated that particular approach to the courts like never before, although I find fault with preceding presidential appointments as well.
Yes.
Yeah. The answer to the question, shall we make the federal courts more representative because they are having to fill in the interstices of the law, the answer is no. But I think we are missing something when we don't mention at least that there's never been such a transfer of power by the Congress in the history of the federal judiciary. There's never been a transfer that would compare with the power that has been transferred to administrative agencies by the Congress.
I agree.
And no one has suggested that the administrative agents ought to be representative. They're not representative any more than the courts are. The court, the power that the courts have to operate on is infinitesimal compared to the power that the Congress has delegated to the administrative agencies of this government.
That's a good, very good criticism. I'm glad you made it.
When I add something to that, Mr. Fine, it's not simply that Congress has been enacting open-ended statutes, but it has proposed an amendment to the Constitution that is as open-ended as anything can be. I'm referring, of course, to the ERA. What is distinct about that proposed amendment to the Constitution is that it refers to rights, but in no way, and in this respect, it is distinct There is no other constitutional amendment that doesn't specify the rights that are to be handed out equally or dealt with equally. This is an invitation to the courts to govern us with respect to this very important matter. Men, women, children, and so forth and so on. This is something that is deplorable, this yielding on the part of Congress, yielding to the administrative agencies, yielding to the courts and so forth. And if that goes on, in a sense, all right, you say it's been going on, let's admit it, and let's put up with this bad thing, then I see no reason why judges should not be elected. And why not, if that's what we want, and a representative judiciary? Why not elect judges?
The only idea of what we're going to do with the federal judiciary, for many years I've said that you might consider giving judges terms of office, like 12 or 14 years. 12 years is term in New York, for example. And then you stand for reconfirmation. You could retire or stand for reconfirmation. You'd still have a, what's the equivalent of lifetime appointment if you did not want to stand for reconfirmation, but it would give a modicum of control. You don't want much.
I think our political processes give that kind of balance. I think we see an ebb and flow, and a country sometimes moves left of center, then moves to the right of center. Now we have a new administration. I think whatever imbalance you may perceive in the judiciary 4 years from now will be corrected.
Well, if he can get 300 appointments, maybe that's so.
Yeah. And this concludes another public policy forum presented by the American Enterprise Institute for Public Policy Research. On behalf of AEI, our hearty thanks to the distinguished and expert panelists, Dr. Sheldon Goldman, the Honorable Griffin Bell, Senator Orrin Hatch, and Dr. Walter Berns, and to our guests and experts in the audience for their participation. Goodbye from Washington.
It is the aim of AEI to clarify issues of the day by presenting many viewpoints, in the hope that by doing so, those who wish to learn about the decision-making process will benefit from such a free exchange of informed and enlightened opinion. This Public Policy Forum series is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C. AEI is a nonprofit, nonpartisan, publicly supported research and education organization. Information on this and other subject areas, including government regulation, economic policy, social security and retirement, health policy, legal policy, tax policy, political and social processes, energy policy, defense policy, and international affairs, is available from the Institute. For a transcript of this program, send $3.75 to the American Enterprise Institute, 1150 17th Street Northwest, Washington, D.C. 20036.